So I'm going to separate out the detainees at Guantanamo in a few categories that I think pose different problems. First, there are the detainees that even the United States acknowledges can be returned safely. Unfortunately, among this group are a sizable number, an estimate is somewhere between 50 and 70, who cannot and should not be returned to their home countries because of credible fears of torture or other abuse upon return. Just to give you a sense of who we're talking about, one subcategory in this group is a group of 17 Chinese Uyghurs. Uyghurs are Muslims from the western part of China who were sold to the United States by bounty hunters in Pakistan. The United States has long recognized that these men pose absolutely no risk to the United States or its allies, but it has also recognized, to its credit, that these men cannot be returned to China because they would be at serious risk of persecution and abuse, even possibly execution. We've seen China execute Uyghurs recently. All of these men have been accused of being part of a separatist movement in China's Xinjiang province. In 2006, the United States convinced Albania, of all places, to take 5 of these men. But although the United States has been actively pressing other governments to help with resettlement of the remaining Uyghurs, it has had little luck, and it has refused to grant any of the Uyghurs asylum in the United States. So even though everyone, except for China, recognizes that these men are not a threat, they remain on Guantanamo. They've been at Guantanamo now for 6 years. Other prisoners, including several from Tunisia, Algeria, Libya, other countries with a well-documented record of torture, have expressed similarly credible fears of return, fears of persecution and abuse. In some cases, the US has accepted these fears as legitimate and declined to transfer them back to their home countries. In other cases, however, the US has either ignored their claims of abuse or fear of abuse, or has failed to ask them about it, or has accepted what are known as diplomatic assurances, which are diplomatic promises by these abusive governments that they won't abuse these people if they're returned. Now think about it, accepting a promise from Syria or Libya or Algeria that you're going to treat these people humanely, and the US accepts those promises. We now know of several Russians and at least one Tunisian detainee who were returned on the basis of diplomatic assurances and abused upon return. We also know of 2 Libyans who've been held in indefinite detention without charge since their return. We don't know how they've been treated because it's impossible to get information about people in Libyan custody, or at least very, very difficult. So that shows you, I think, the validity of these so-called diplomatic assurances. In order to be more fair, I think the United States needs to create a system by which detainees are provided advance notice of the possibility of return and an opportunity to object to their transfer and to articulate why they would fear return. And they need to be able to do this before some kind of independent adjudicator, such as a federal court. Now, the odds are good, and clearly in the cases of the Chinese Uyghurs and some others, that there will be a group that an independent adjudicator will fairly assess should not be returned. So that raises the question of what do we do with these people? The United States complains that no other country will accept people who it cannot and should not return to their home countries. With the exception of Albania, no other country has accepted non-resident third country nationals. But think about it. Why would other countries decide to accept these people when the United States itself has refused to accept them? And I think that gets to the core of the problem. The rest of the world says, you've created this mess and you want us to solve it, without the United States even taking a step in the direction of trying to solve it itself. So I would propose that the United States should break the impasse about these people at Guantanamo who can't be returned by accepting at least some number of them into the United States. perhaps the Uyghurs, who, by the way, there is a very well-established Uyghur community within the United States that has expressed the willingness to integrate these people into their communities and to help them resettle and to help them acculturate and so forth. If the United States were to accept some number of these people, I think it would then have a much stronger case to make in its relations with other countries to encourage other countries to themselves accept these people. It would make it clear to the rest of the world that we're not trying to shift the entire burden, we're just asking for some kind of burden sharing. And I think at that point, countries that have long condemned Guantanamo would be much more willing to couple their condemnation of Guantanamo with actual concrete action to help close it. A second and sizable group of detainees, approximately 80 people, are those whom the United States says it plans to prosecute. Now, we are certainly in favor of prosecuting those people who are implicated in criminal acts. We believe by prosecuting them, the United States diminishes their status to common criminal. It is, I think, a much better alternative than calling them an enemy combatant, which gives them a status that many of them embrace. By prosecuting them, it legitimates their detention in the eyes of the world and brings, I think, some closure to the victims of terrorist crimes. But it is fundamental that these trials have to meet the criteria of basic fairness. Otherwise, the verdict will lack legitimacy, and the court system, as much as the defendants, will be on trial. This is certainly what we've seen to date with the military commissions process. As recent events have underscored, and maybe we can talk about this a bit in the question and answer period, the commissions lack independence and they're vulnerable to political manipulation. And I would submit that that may be why we're seeing a sudden rush of prosecutions right now, after years in which the commissions have gone nowhere. The commissions lack basic due process guarantees, preventing, for example, defendants from being able to effectively confront the evidence against them, which is, of course, a basic attribute of a fair trial. The commissions do not even satisfy the criteria of swift justice, which was one of the justifications put forward when they were established. More than 6 years have passed since the administration announced the creation of these commissions, and to date they have only had one success: the conviction of an Australian, David Hicks, by guilty plea, so it wasn't even a full trial. And Hicks is now back in his home country. He's a free man. He served a 9-month sentence. The Bush administration tries to justify the military commission system by arguing that it cannot try Guantanamo detainees in the civilian courts because of stringent evidentiary rules and because it will be required to make public classified information. But as several former judges and prosecutors have argued in court, including in a very important report that was issued a couple of weeks ago by Human Rights First, and if you're interested in this question, I suggest that you visit their website and look at this report. As these prosecutors and judges have argued, concerns about the difficulty of trying these detainees in federal court are overblown and misleading. In fact, a reading of the Military Commissions Act of 2006 suggests that it's the administration's real concern may be that much of the evidence it has obtained during the course of detaining these people has been tainted by coercion and abuse. This is evidence that would not be allowed in a federal court. But notably, the rules of the military commissions allow the introduction of evidence obtained through cruel and inhuman interrogation methods, so long as it was obtained prior to 2006, does not rise to the level of torture, but of course that opens up a can of worms because we have the administration's very narrow and inaccurate definition of what constitutes torture.